your initial observations of what you read.
Yeah, I've seen the judgment and I've gone through it. I mean, for me, it is disappointing because the court was seriously misdirected in terms of what the real issue was before the court. The real issue before the court, in my opinion, I mean, given my analysis of the Constitution and the facts, the real issue before the court was whether or not, at the point of becoming a member of parliament, James Quayson owed allegiance to Ghana and any other country at the point of becoming a member of parliament. That is the real issue, because as a Supreme Court, their job is to interpret the text of the Constitution, not to go back and preside over the processes of becoming a member of parliament. No. What happens when you pick nominations? What happens when you file nominations? What happens when you contest elections? How the elections are regulated? All those are matters before the point of becoming a member of parliament. And all those are matters that should properly be regulated by statute. So that is the issue before the court. And so for me, it was disappointing that they went to the question of how does one qualify to file nominations. That is not what Article 94 2A, that is not what Article 94 2A deals with. 94 2A deals with when you become a member of parliament. At that point, do you owe allegiance to another country or not? It's as simple as that. If you don't owe allegiance to another country, at the point when you become a member of parliament, then you don't have a problem. But if you owe allegiance to another country, at the point that you become a member of parliament, then there's a problem. And then even if you become a member of parliament and subsequently you assume allegiance to another country other than the government of Ghana, then you have a problem also there. But what the court did was to say, oh, I mean, yeah, we are looking at the qualifications to become a member of parliament. But then it is necessary to start from the qualification to file, to contest for elections, to become a member of parliament. So you can see clearly that they were misdirected. And that misdirection is based on an earlier decision of the Supreme Court in the Zaneto case. In the Zaneto case, the court said that, well, we agree with the NDC that the point at which we should be looking at qualification is when you go to file with the Electoral Commission. Because in the case of Zaneto, she and Ni Ashiti had contested parliamentary primaries for the NDC. And Zaneto won. When Zaneto won, Ni Ashiti went to court saying that Zaneto was not a registered voter in that constituency. And therefore, she wasn't qualified to contest as a parliamentary candidate for the NDC in that constituency. Then the NDC party, which was an interested party in the matter, joined Zaneto and then argued in that case that, well, the most important point to determine qualification to contest elections is at the point of filing nominations. And since we haven't reached the point of filing nominations yet, the action brought by Ni Ashiti was unfounded, and so Zaneto was not disqualified from contesting elections on the ticket of NDC in that constituency. And then the Supreme Court said they agreed with the argument of NDC. And then they laid the principle that the point for determining eligibility is the point of filing nominations. Now, the Supreme Court in James Quayson case is saying that we have already established the principle that the point for determining eligibility is the point of filing of nominations. And so, in the Quayson case, we have to go back to when he filed nominations to determine whether or not at that point he was eligible to contest. And so if you apply that, since the evidence is that at the point of filing, he had not yet received his renunciation certificate, even though the Electoral Commission saw no issue with that and said he could go ahead and then file. But then by election day, his certificate had arrived. And by the day that he was being sworn in as a member of parliament, even though his certificate had arrived, so far as they are concerned, if they applied their earlier decision in Vaneto, he was not even qualified to have filed to contest. And so, even though at the point of the election and then also at the point of swearing in, he was qualified, they were using the point of filing as the reference date because that was the principle that was enunciated in the ex parte Vaneto case. I'm saying that that is a wrong position to take of the law. I think that the Supreme Court in the Vaneto case was wrong, and I think that the Supreme Court again in the Quayson case is wrong because you need to read the letter of the Constitution. 94 is talking about qualification to become a member of Parliament. But the Supreme Court has assumed the job of determining qualification to file to contest the election. That leads to you becoming a member of Parliament. Even if they say that there is a vacuum there and there should be clear regulations governing it, that is the responsibility of Parliament. Don't forget that the Constitution has given the Electoral Commission the mandate to make regulations governing elections. And so all the Supreme Court needed to do was say, look, as for us, our job is to read the Constitution and interpret it, not to make laws for the Electoral Commission. Article 94(2) talks about when somebody is becoming a member of Parliament and he owes allegiance to another country, is he qualified to become a member of Parliament? No. And so the question is, at what point do you become a member of Parliament? You become a member of Parliament after you have been elected and you are about to be sworn in as a member of Parliament. So if at that point you still owe allegiance to another country, then you are not qualified to be sworn in as a member of Parliament. Or if after you have been sworn in, we discover that at the point of becoming a member of Parliament or being sworn in, you still owe allegiance to another country, your seat will be declared vacant. Or even if you did not, but subsequently, once a member of Parliament, you go and assume allegiance to another country, your seat will be declared vacant. That is what the Supreme Court ought to do, and not bog itself down with the question of what happens when you file nominations, what happens on the day of contest, what happens between the day of contest, the election day, and then the day when you are being sworn in as a member of Parliament. That, properly speaking, is the subject of regulation by the Electoral Commission. This is my view of the matter, and I think that our Supreme Court is very, very wrong on this matter.
So to you, is it at the point of the person taking the oath of office and the oath of allegiance?
Exactly. That is what the Constitution says. Just read 94. 94 is talking about qualification to become a member of Parliament. Filing of nomination forms, the character of nomination forms, the things that you do on a nomination form, all those are matters governed by other legislation. That is the Representation of the People's Act. It is not the duty of the Supreme Court to interpret those legislation. That is the responsibility of the High Court. So if there is a dispute regarding Article 94, the Supreme Court should limit itself to interpreting Article 94, not to make laws to cover up for areas that they think PNC law, what they call the Representation of People's Law, did not make provision for. When you do that, you are crossing the boundary of the province of the Supreme Court.
So to you, the Supreme Court only comes in when the person is about to become the member of parliament, as in when the person is about to take the oath and assume office. That is where they start from.
That is what Article 94 2 deals with. Article 94 2 deals with at the point of becoming a member of parliament. Did you owe allegiance to another country? Yes, no. When you are a member of parliament, have you assumed allegiance to another country? Yes, no. If yes, then you are disqualified. Your seat has to be declared vacant.
So
Article 94 doesn't talk about, qualifications to file nominations, qualifications to contest the elections. 94 doesn't talk about contest at all. It talks about becoming a member of parliament. I agree that there are processes leading to you becoming a member of parliament, but that is not what the Constitution is concerned about. That should be the subject of legislation. That is why you have the Representation of the People's Law, which is governing elections. So you have to look at the language of that legislation and find out whether it has enacted provisions regarding qualifications to file and contest. It doesn't do that. So I'm surprised that, we are going through all these troubles that we are going through, because the language is very simple and very straightforward. And indeed, that is why we decided that we will not take a decision on the Chief Justice nominee. Wanted to listen to her jurisprudence on that matter, because it was a fresh matter. It's the subject of national controversy. There's some dispute between different interest groups regarding at what point we determine a person's qualification to become a member of parliament. And because she had told us during her verdict that she is a textualist, and a textualist is somebody that sticks to the text of the Constitution. The person does not, make law in the name of constitutional interpretation. And so I was very, very confident that a textualist should not have joined the rest of the bench to agree with them that Quayson was disqualified. And so I wanted to hear the reasoning, because no matter how much constitutional law you know, sometimes we're all fallible. So I wanted to hear the reasoning myself to see whether perhaps I missed something. But when I read the reasoning, I don't see that I have missed anything. I just see that the Supreme Court has overshot its boundaries.
So now what happens? Because you were saying you might ask for the opportunity to ask subsequent questions. What would you do now?
Oh, I mean, it's not my decision. It's the decision of the caucus. So we'll be meeting this morning. I'm actually late for the meeting. We have an 8 o'clock meeting this morning to take a decision as, we said we would communicate our position after we have heard the reasons. Initially, we were told that the Supreme Court would give its reasoning on or before the 7th. Luckily, they have given it even earlier than Parliament has resumed. And so we have an opportunity to take a position and guide our colleagues on the floor of the House. So I cannot alone tell you what will happen. It will be a collective decision of all of us as a caucus, and then I believe that it will be communicated.
So Honorable Ayariga will say at the caucus meeting what he thinks, but the decision is left to the caucus to take.
Oh yeah, I mean, what do they call it? There are so many factors that will be taken into consideration in taking a decision. It's not just this ruling. There will be so many other considerations. I mean, at the end of the day, whether you like it or not, the Supreme Court is made up of not less than 5 people sitting, depending on the matter, not less than 7, and then not less than 9 ultimately. And so, even though we were assessing her for the job of Chief Justice, there are other things. Chief Justice is largely an administrative, responsibility. Your jurisprudence is important, but you are not alone. You are either 5, 7, or 9. You are influential as the Chief Justice, but ultimately, each member of the bench is supposed to be independent-minded and not necessarily kowtowing to the whims and caprices of a Chief Justice. So we will think broadly about the problem, and then we'll take a decision.
But left to Honorable Mahama Ayariga alone, you have had opportunity to ask the questions that have arisen in your mind.
I have answered the questions that I wanted answered.
Oh, okay.
I'm not satisfied with her jurisprudence.
Okay.
But whether or not my dissatisfaction means she should not be approved as a Chief Justice is a different matter. Okay. But I'm not satisfied with her jurisprudence, and I'm not satisfied with the jurisprudence of all 9 of them who sat in the matter. I don't think they did the right thing.
Honorable, thank you very much for your time.
I appreciate it.
Yeah. Honorable Mahama Ayariga is member of